Wait. Verification.
Item number 1.
I am getting for the respondents.
Either it can be done that way. Better. Amount is also changed. Date is also changed. Effect of publication is everything.
Get the bullets. Item number 2 to 9.
And for the response. So those mistakes are quite obvious. Except for the last one. Last one we will not. Sorry, we will not consider that. You do whatever you want. We are not suggesting, we are not saying anything. Whatever remedy you have in law, you can pursue. We are not saying anything about that. But the other mistakes, yeah. So in second paragraph, the number is wrongly typed. 571 instead of 517. Many mistakes. And then 1664 instead of 664 of 23. And then 1665 of 23. So this is in paragraph 2. In paragraph 4.
The assistant professor, in case of the first 3 lead petitioners, that is WPCT is 69, 70 and 71. And it would be professor in case of petitioner, WPCT 72 of 2025.
Professor, it can be.
And professor.
And in
So the applicant before the tribunal are doctors posted as assistant professors.
In WPCT, my lord, 69, 70 and 71. And my lord, professor in case of WPCT 72.
So one slash and professor will do. One slash and professor will do. Then it will apply to the person who is professor. Because less done, the better.
Yes, sir.
So many mistakes. So assistant professor slash professor in paragraph 4 because one of them was professor. In paragraph 2, there is some typographical error in the numbers. Yes, we have just seen it is 517 instead of 571, 1664 instead of 664, 2023 instead of 24, again 2023 instead of 24. Paragraph 4 also there is some other mistake. 7,400 should be
74,000 in case of
7,400.
yes, sir, in case of first three lead petitioner.
69, 70 and 71.
And my lord, it would be 1,34,500
For the professor.
for the professor.
So here also we can do 74,000 slash 134,500.
Yes, my lord.
That will suffice.
And my lord, the next line again. The 91,100, my lord, it has been correctly recorded in case of 69, 70 and 71.
Yes, what is this mistake?
My lord, here the day of the professor would be 165,400. That has
So there here also slash 165.
400.
Five one two. Hey, 151.
না না ওটা ভুল আছে 165,500.
No, it's 71. 76.
Which day? In paragraph 5, paragraph 4. So the office order is 27/9/23.
79.
In case of the first three and my lord or for the first two,
Yes.
86,07,2023 for the last two.
So 26/7/2023 for petitioners of
71 and
70.
69.
My lord, 26,07,2023.
just a minute. 26/7/23 for petitioners of WPCT number
71 and 72.
71 and 72 of 2023.
Well, 27/9/2023, that is 69 and 70.
Hmm?
27th of September 2023, that will be in 69 2025 and 70 of 2025. This rule is
69, 70, 27, 9.
27. And 26,7,2023 for 71 and 72.
Yes.
But then from the top, but it will be 57,700.
6700.
Which one? Oh, yeah.
So fifth paragraph, fourth paragraph, there is something else.
Lines from the top,
Yes.
it will be 67,700. Stroke
74,000.
no, my lord, first it will be 67,700 for the first three petitioners, and it will be 100 for.
No, please.
10th line from the top, 10th line.
Please, all of you don't, please, just allow it. There's too much confusion as it is because of so many typographical errors. 6,700 will be,
6,700.
yes,
This will be for the first three petitioners.
yes,
100 for the fourth petitioner.
1, 2, 3, 100.
Yes, Father.
This is the,
Fourth petitioner. And by the same line has been recorded as 7400
that should be 74,000.
for the first three petitioners, and for the fourth petitioner, I got 134,500.
So 134,500 is for the
Fourth petitioner.
fourth rate petition. So WPCT 72.
72. Followed in paragraph number 5, the second line,
Yes,
but again the 27092023,
26,723.
and my lord, then the just the line below that, there is the date 5/3/2024.
Yes,
That is for the first two writ petitioners, and for the last two writ petitioners, it will be 25/08/2023.
for 71 and 72.
For
71 and
71 and 72. My lord. And my lord, then my lord, the next
Correct, 13.
add in that paragraph number 13, 13.
Yes.
That 5 lines from the top,
So 74,000
2000 has been correctly recorded.
slash,
That one it will be 134,500.
First is the
Now, my lord, last paragraph, paragraph number 18. So the only these 8 numbers are there. 3 lines from the top, my lord.
517
517.
of 24,
517 of 2024. And my lord,
1664 of 23,
of 22.
of 23,
2023.
3,
Three.
and 1665 of 23.
এটা বলে দাও, appearance টা অন্য বলেছে, page 2 তে। ওটা বলে দাও। ওটা পিটিশনের নাম, রেসপন্ডেন্ট হবে ওটা। হ্যাঁ, আছে, বিলকুল।
that page 2, where the appearance has been recorded, the third paragraph is recorded as for the petitioner number 1.
It should be respondent.
এখানে কথা কোনো জায়গা নেই।
Take down.
zero has been recorded, that will be 74,000 for the first three lead petitioners,
Yes,
and my lord, it would be 134,500 for the,
correct. 74,000.
and my lord, 134,500
For 72.
for,
One more has to be added in paragraph 4, where we have
my lord, I'm just handing over the corrections, my lord, perhaps that this is the corrected copy. I'm so grateful, my lord, much obliged, my lord, deeply obliged. My senior is also here.
errors are admitted by everyone. It's unfortunate, so many errors of omission and commission has tripped. It has to be rectified. What? No, this should not happen, but it has happened. What can? It's only a human error. What else can we say? Yes.
Item number 10,
My lord, madam, two typographical errors are there.
In this also.
Very minute. My lord, by Leonard Junior, my lord, to indicate. My lord,
35. So case number has been wrongly mentioned.
my lord, it should be 35
35 instead of
of 2025, man.
55.
It should be, my lord, 35 of 2025, man.
Oh, both of the digits are wrong. The case number.
eleven,
Lordship, I appear on behalf of respondents 1 and 2. This is the trustee matter, Lordship, where the appellants do not appear. When every time your Lordships threaten them of dismissal, they appear on one date and then on subsequent dates they do not. And I am suffering an injunction order.
There is an interim order.
Yes, Lordship.
In these proceedings.
Yes, Lordship. 20th May 2010. So I pray, Lordship, the appeal be dismissed.
And where is FMA 565?
That is not assigned to this bench.
Arising out of the same order.
No, Lordship, different order.
No, there is a mention in earlier order that
It's the same suit but different order.
subsequent orders have been.
Subsequent order, yes.
So that is before which bench?
Regular bench Lordship.
Fine. Even if you have. So this has been assigned to us.
Yes, specially assigned.
Isn't it better that both the matters should be considered together?
That
Two
is
benches
on a
dealing with
different
orders arising
point.
out.
That
We
is-
have understood what you say still. Both the orders are arising out of the same proceedings.
Actually, this was before this bench because originally Justice Harish Tandon's bench was listening to this matter, but then subsequently
That's
it
all
was
right, but
assigned.
after the assignment, we have recorded that we were finally informed that there is another appeal. Before the assignment, there is no such record here. It's only after the assignment that fact has been recorded. So we have waited for them. If they are not appearing, there they all must be appearing. It may expedite your matter also.
Even in that, they're not appearing. And
That is
as-
by you. That is by you. That is your appeal. Well, why not it be placed with the same, since another appeal is arising out of the same proceedings? We think it is better that it should be assigned before that bench.
Lordship, as Lordship deems fit.
After assignment of
Item number 17.
For the petitioners.
Seniority is on her way, lots of praying for very short Passover.
No, no, last occasion also they prayed for time, my lord.
Very short Passover, Lords.
She'll come. We have already heard this one.
But it was already heard on the last occasion.
Where is that? You were relying upon a gazette notification.
Yes, my lord, the Central Civil Services Rules 2021, my lord.
11A.
11. Rule 50, Subrule 11.
Rule
50, Subrule 11A.
11A.
11.
So you are not suffering with any mental or physical disability. And tribunal has rejected your claim.
Order passed by tribunal only mentions the first part of the order and not the latter portion of the order, my lord.
Rule 50 of CCS pension rules. TCS pension rule. Central Civil Services Pension. Central Civil Services, it should be like this. We are having two CCA rules but no pension rules. PS rules. Why having a duplicate? Give one back to the liability. Ask them to get Swami's CCS pension, that is Swami CCA service, same publication. Is there or only 50? So 50 and 11A, there is any difference?
Sub rule 11A is, the rule is 50 and the sub rule is 11A.
Yes.
The latter part of the order, which where it was stated that the pensioner for life, if the siblings were wholly dependent upon the government servant or pensioner immediately before his or her death, it was not considered by the Honorable Tribunal. That
Where are you reading?
11A.
11A. No, the tribunal's order 6.1.
Yes.
Tribunal's consideration is that in para 6.1.
6.64, my lord. That the first part of the order is mentioned.
6.4, there is no. Where is 6.4? There is 6.
6.1, my lord, paragraph 6.1.
4, yes. This is a sub-clause 4 of Rule 50.
Yes, my lord.
So this is in any way different from the 11A, or it is the
The full order was not incorporated in the finding, my lord. The 11A, my lord, kindly come to page 76, my lord.
Yes.
Where a deceased government servant or pensioner is not survived by widow or widower, or a child or parents eligible for family pension, or if the widow or widower, children and parents of the government servant or pensioner cease to be eligible for family pension, the family pension at the rate sub rule 2 shall be payable to the dependent sibling suffering from mental or physical stability of the government servant.
So a dependent sibling suffering from a mental or physical disability. This
There is an or here, my lord, or pensioner for life.
No, there is no or.
The siblings were wholly dependent upon the government servant.
No, this dependent sibling suffering from mental or physical disability is one thing.
One thing.
And this is a government servant or pensioner. So this sibling has to be either of the government servant or pensioner for life.
The siblings were wholly dependent.
And then the second qualification is that if they were wholly dependent on the government servant.
Yes, ma'am.
Immediately before his death.
And the petitioner is wholly dependent on the government servant.
If the sibling, which sibling? The sibling, dependent sibling suffering from death. If the sibling wholly dependent upon the government servant or pensioner immediately before. So what is the interpretation according to you?
This part, or pensioner for life, if the siblings were wholly dependent upon the government servant or pension immediately before after his or her death. But the petitioner was dependent on the brother because she's unmarried and she was solely dependent on her brother, my lord. The brother also in the lifetime did not marry. The tribunal might have missed that particular portion in the order while
No, it did not. The tribunal has taken note of a different provision. The tribunal has taken note of Rule 56(4). The 56(4) is a different provision. Where is the CCS pen? Got it. Get the new rule.
11A ought to have been taken into consideration by them. My lord.
Yes, we have understood what you are saying, but the tribunal has taken note of it.
6. The pension payable to the members of the family of the deceased government servant.
Fifty sub rule 6. Where is 50 sub rule 6? Is it
Lord,
there?
Page 72, my lord. Kindly come to page.
Sub rule 6.
Yes, my lord. Sub rule 6 is there. Page 72.
Yes, this is it. So this is what the tribunal has taken note of.
In a reply, my lord, we have incorporated at the time of the pleadings, we in our reply also in a rejoinder, we have mentioned about this rule, but the tribunal did not take this into consideration, my lord. No, she's a financial.
Where is the definition of family? Oh, this is the definition. Widow, widower. What is so 6, 4 and 11, they have to be reconciled. You will have to rely upon some judgment on interpretation, otherwise you will have to assist us with some judgment on the how this is to be interpreted, these two provisions. Merely saying that it has to be read that way is not sufficient. This will have to be considered. 56, 11A. This must have been considered by the court in some decision. Must have been. Can't be the for why you have not come with any judgment. You should have. Not a new provision. It must have been considered in some decision. This is amendment of 21. With some judgment.
Can you give me accommodation, my lord, for 1 week? Then I shall arrange for the judgments and please refer your lordship, my
The
lord.
issue arising for consideration is
18,
Yes, I appear for the recognition. In 18 to 14 February 1997, Railway Recruitment Board Millard had issued an application.
You are for the railway.
And Millard, we were the aspirants as against the post of Millard, that is the Millard inquiry cum reservation clerk, commercial clerk, and ticket collector. Now, Millard, we applied for the post with the respect of Millard 15 and 17 categories. That is these categories. This post indicates that the 15 and 17, be that as it may, were called for the written test to appear. Subsequently, Millard, we came to know that
In service or open recruit? In service or open recruit?
open recruit. No, we applied. We subsequently, Millard, came to know that that particular records, the examination had been cancelled. We questioned, Millard, the propriety of such cancellation. We approached the Honorable Tribunal. Now, Millard, the Honorable Tribunal initially was pleased to, Millard, pass an interim order, Millard, was to the extent, Millard, that do not publish the result. At the same time, granted liberty, because in the meantime, Millard, the second examination, another examination, the notification was published.
Next recruitment.
Next. So we were granted liberty, Millard, to appear without prejudice. We did not appear, Millard. We continued with the battle. Now, Millard, ultimately our contentions could not be countenanced, and accordingly, Millard, the way applications were dismissed. 2007. Now, Millard, we preferred a writ application before your Lordship's court, WPST, that is Millard Tribunal application, WPCT. Millard, this application ultimately was allowed by an order dated, Millard, 29 January 2014. Now, Millard, the sum and substance of the order, it has page, Millard, 29, 29 January 27. Twenty-nine is the, Millard, operative part, Millard. It starts from third paragraph, 29 page. We found that since
You were a petitioner in this.
My application starts from page 31. The order passed on my request. I'm concerned with the WPCD 722. I got the same benefit as that was granted Miller in that.
Yes, then what happened?
Now, Miller, what happened?
You were
I-
appointed.
Yes, 27 March 2014. Millard, your lordships possibly noticed there is a specific direction of the Honorable High Court that my appointment would be guided, Millard, by the recruitment rules 1997 that was prevailing. Now, the point, Millard, that came later on after joining Millard, I made a representation to the authority that my legal battle started within a 1 year from the date of cancellation of the examination. Ultimately, I succeeded, Millard, in 2014. It is the delay that has been attributable, delay is attributable to the authority because of your inertia, executive inertia and your inaction. I was not able to, I could not be able to join the service. Ultimately, because of the High Court's intervention, Millard, my appointment was granted. So I should not be made to suffer, and you cannot claim privilege of your own irresponsibility by denying the notional benefit of my promotion. I approached Millard, the authority flatly denied it. Now, Millard,
Approach them for what?
Huh?
Approach them for what?
Approach them for giving a notional benefit from the date which I should have been actually appointed.
Which is?
Well, a pensionary benefit.
Which is from which date?
From the date, Millard, 1999. My application, Millard, kindly sees page 164. The Honorable Tribunal said that they rejected my claim.
What was your request? We want to see that.
Now, Millard, my request, page 145. To give a date of the filing of the application, Millard. Millard, kindly see page 98. Tribunal application. What was my prayer?
At 145, we are looking at your representation, which you filed in 2016.
I request your lordship, Millard, with humility. If what is the prayer, I cannot make a new case in the which I have not appeared before the tribunal. That is your lordship's consistent view. The prayer in substance and the pleading, kindly, Millard, takes pen to turn page 98. Page 98.
From the date of filing writ petition.
Filing the OA application.
OA application.
Now, Millard, the claim, Millard, has to be counted from the date, Millard.
Yes.
Now, Millard, in the meantime, after filing this writ petition, Millard, Millard, kindly turns, Millard, the application CAN number 1 of 2023, 2024. Can 1 of 2024. আচ্ছা আপনার কাছে page 6. No, can applicable. My lords, একটু ক্যানটা বার করে দেবেন, can 1.
Page,
Page 6, my lords. My lord, the read petition, the WPCT was admitted on October 13, 2023. And my lord, during the pendency of this read petition, the office order dated 31st October 2023, when, my lord, the petitioners were switched over from new pension scheme to old pension schemes as they are eligible for coverage under Railway Service Pension Rules 1993. Office order, my lord, dated 31st October 2023 is there. My lord, that is at page 10, my lord. If your lordships kindly, my lord, take pain, my lord, to turn page 10, your lordships will be pleased to find that the sum and substance of this memo, it says, may I read for my lords, in terms of Railway Boards dated 10/3/2023, DOP dated 3rd March 2023 for coverage under Railway Service Pension Rules 1993 in place of National Pension System, the following railway employees, commercial of Shialda Division, who were recruited against the post vacancies advertisement notified for recruitment on or before 26, on or before, kindly take note of this fact, before 22nd December 2003. But they had joined railway service on or after 1/1/2004 and submitted their option before 31st August 2023 for switching over from NPS to OPS have been found eligible for coverage under Railway Service Pension Rules as per provisions contained in this. This has approval of the competent authority accordingly. Now, my lord, my names, our names are featured as against serial number 10, 11, 14.
15 and 16.
Yes. Deeply obliged, and 17 also.
17 also.
Taposh Kumar Bishwas, তাই তো?
He is also a petitioner.
Taposh Kumar Bishwas.
17 also. 17 also.
Yes. 17 also. Now, my lord,
Your notional benefit you are asking only for pension.
There are other subject to correction, 10, 11, 14, that also there.
আমি তো বললাম সেটা। I have
10, 11, 14 years. Sir.
I said.
15, 16, 17.
17.
Now, my lord, my prayer is that the policy decision of the government for transformation of benefit, my lord, new pension to old pension scheme, that has been conferred upon us, a conscious decision has been taken by the government. This is also in line with, not in conflict with, my lord, with the order dated 29 January, government had taken note of all these attendant circumstances, and that is why the conferment of benefit, I would say, my lord, not with confidence, but with humility, my lord, subject to what my lords will say, that this is absolutely in line with the previous orders of the High Court, as well as keeping in view of the entire country, my lord, the employees. Now, my lord, I got the benefit, my names have been featured. So, now, my lord, that is why I said that if my recruitment is guided by 1997, if the pension scheme that has been specifically guided that yes, I am entitled, subsequently, my lord, government said that no, this benefit cannot be conferred upon you during the pendency of this. So today, after filing of this application, so this is malafide, number one. When a matter is sub judice, my lord, there was a time, my lord, I am sorry that I am not armed with this, that in a judicial process, even any kind of interference or statement, my lord, made with regard to any pending proceeding, my lord, and there was a time in Calcutta as well as before the Supreme Court also, my lord, that the court, my lord, did not tolerate, my lord, such interference from any corner whatsoever. Because, my lord, after this, my lord, order, the executives enrolled into the judicial order, subject to what my lord say, that when a right has been crystallized by reason of a confirmed decision, conscious decision, and it gives the birth of promissory estoppel, and it also demolishes the predictable contour of a decision-making process of the authority.
Where
which
is that stand taken by them? From where can you show that they have taken such a stand? So you are saying that benefit of this notification of office order of 31/10/23 is not being extended because of pendency of the writ proceedings.
After filing this writ petition, they said we are, that is I will let us filed by them. I came to know about such fact from after filing. 6. No.
That's the So whatever that decision.
They said, two things. The answering respondent reiterates that the Honorable High Court Calcutta was pleased to dispose. Just a minute. This is in relation to.
No, is it before us? We are asking you. Is it before us? Is it in the record? You are saying that they have taken certain stand which you are aggrieved by. Where is that in the record? Is it there? How do we?
Millard, they have filed the opposition, Millard.
It's the opposition.
They have filed the opposition.
This was during the pendency of the writ.
Correct. That he is saying. So where is that?
Yes, Millard. They have categorically said that the benefit that has been conferred, that
And then you say why we are so meticulous.
yes, that creates uneasiness. No, এটা কি সার্ভিস করেছিলেন অপোজিশনটা, একটা ওই যে ক্যান অফ ওয়ান না, আপনি অপোজিশনটা সার্ভিস করেছিলেন? Where is that? না বললে কি করে হবে? না তো ওদের ওরা তো সার্ভিস করেছে, they have served upon us. I say that during the instant pendency of the instant writ petition, that is, Millard, can one, the affidavit, that is in my reply, I say that during the pendency of the instant application by an officer at such and such, the petitioners switched over from such and such rules. It is stated that the policy decision of the government for transformation of benefit from new scheme to old pension scheme, as that has been conferred upon the employees of the respondent, has clearly indicated that such benefit covers all those employees who were appointed by virtue of notification issued prior to 2004. The case is made applicable to the present applicant, taking note of the fact they are appointed in pursuance of the notice published prior to 2004. The instant application for appropriate order was filed on 3rd January 2024 with a prayer to take note of the subsequent fact, where the petitioners were allowed switching over from new pension scheme to old pension scheme as they are eligible for coverage under railway pension scheme. Now, surprisingly, the issuance of the order of stay of switching over NPS to OPS, that is original pension scheme of the respondent, such and such authorities by letter dated, there is a letter 17/5 is nothing but an afterthought, and such action is proved to be, there is a letter.
You have started reading without telling us where you are.
No,
reading.
sorry, Millard,
We are
no,
still trying-
affidavit in reply.
Which paragraph? Yes.
Paragraph, my lord, that is, my lord, paragraph J, page 4 starts from.
G.
Paragraph, just a minute, my lord. Paragraph 6, page 5. There is a specific, my lord, notification. কোথায় notification টা? 75.
This affidavit in reply.
এটা প্যারাগ্রাফ 5 পড়লাম।
Supplementary affidavit. Affidavit in opposition. Supplementary affidavit filed on behalf of the respondents. Affidavit of service.
This was, my lord, withdrawn.
Service. Replies, finally
They
located.
have said, my lord, this was a
Page
letter.
4, just please bear with us for a minute.
Sorry, my lord.
Please, page 4.
Page 5, paragraph 6 of my affidavit in reply, I have categorically stated that after this issuance of the letter, the relevant paragraph is at page 6, where I said the instant.
Yes, we have it now.
No. The 75/2024, my lord, they have relied on
This is it.
ঠিকই আছে। আমাদের opposition to
What's that? It is the reply to Can.
Milord, the relevant paragraph is at, Milord, paragraph 5 of their opposition.
Please, sir, please wait, please. Perfect. Written opposition is there. Right? Can. Is there 2 copies in your brief? Maybe there are 2 copies in your brief. See. Extra copies. All right. Yes, finally, there were 2 copies in the second brief. Yes.
That their contention, their affidavit in opposition in response to Can 1, paragraph 5. Now, why they are unable to, my lord, confer the benefit?
Para 5.
Para 5 of their affidavit in opposition against my Can 1. My lords got it. Opposition. That was affirmed. That we received this copy on 25th June 2024. This was affirmed, my lord, on June 2024.
R1, R2, and R3.
Yes. My lord, they categorically stated the answering respondent states that matter came to notice through Can 1 of 2024 of WPCT 175, where the writ petitioners were allowed to switch over from NPS to OPS by SDHA division of this railway. After thoroughly examining the issue with the existing rule in force, it was found that this could be done either by ignoring the stipulation of RB number 2023 or by lacking information regarding the pendency of the ongoing writ. Instruction has been given to stay order till finalization of the Honorable High Court, Calcutta. Hence, the question of other consequential benefits of extension of pay seniority doesn't arise. The railway notification stay order from such and such March. Copies of the railway board. Now, Milord, 17/5/2024, Milord, we have came to know that this is, Milord, a memo, 17th May.
So what seems to be the dispute there? It's only because this is pending that the moment this is disposed of, you will get everything. The moment it appears prima facie from this affidavit that the moment this is disposed of, you will get everything. They are waiting for result of the writ petition. Perhaps, as it appears.
That is, he is the best man to say, Milord. But
Because it is pending, they are saying that we are keeping it on hold, subject to whatever the High Court may say.
first of all, that the government has, Milord, categorically in no uncertain terms had conferred benefits. There is the memo which I have shown. Today, Milord.
But that's not in dispute now. It is only pending because this is pending.
No, but question is, Milord, the benefit that has, the decision has been taken, which is not prejudicial to the interest of the employee who are before your lordship.
That's a different thing, but where is the dispute we are saying? What is the dispute?
Now, Milord, they are saying their submission before the court is this, that today, Milord, the pension scheme, I made this application that when I was allowed to, Milord, switch over from national pension scheme to the original pension scheme, I only prayed for, that is why your lordship, Milord, directed me to affirm an affidavit saying what I am exactly claiming from this court.
Exactly, that's why again we have come to
No.
that.
Now, Milord, the supplementary affidavit, Milord, that was liberty, was granted. I filed a supplementary.
So what is it? Forget about
I
affidavit.
said, Milord,
What?
I said that I could not join in the year 1999.
All that is over. Now they
All
are
this-
saying that we are giving you the pension scheme and
That
they
is
have
also-
taken a decision that is
Milord,
also.
So, Milord, the pension has
And the consequential also, they say it can only be done after that is
now, Milord,
granted
today,
to you.
Milord, I am only, I did not render my service, Milord, for the period. I cannot claim arrear salary.
Correct.
Correct. So today my prayer must be reasonable. I said because of your laxity and negligence, I was not allowed to join. So notional benefit will have, it is given
The notional benefit is pension only.
only.
So
That is
that
what
they
I
are
am-
already giving. So why?
No, they are giving not from the date, Milord, of filing of the application. Otherwise, Milord, I will get pension maximum, Milord. That calculation I have given as per your lordship.
You don't know. You don't know what they will give. They say that.
That's not explicit. How can I read
Please-
his mind?
Please see what they say in the order passed by them.
That is the order. That is, there is an incomplete order subject to correction. This office memorandum,
You are apprehending something, it appears.
they clearly said, Milord, finally sees what.
Let us see what is their decision to grant the benefit to you. Read it.
Because they, Milord, in this, the present application, practically they said the present application is not bona fide, no case has been made out.
Sir, they say the question of other consequential benefits,
If your
including
lordship says that
fixation of pay seniority, does not arise because at the moment we are not giving it to you. They don't say that it is, they have not decided yet. Doesn't appear unless you can show
No,
that they have taken
Because, Milord, my foundation of the claim, they said it has no basis. The other benefits kindly.
Please read what they have said. Come to page.
153 of your lordship's brief, kindly sees. That is their denial.
No, let us see the denial is now in this can. Come
the
to
can.
page 3.
They categorically.
Instructions has been given to stay the order till finalization of the matter by the High Court. Hence, question of other consequential benefits
No,
does not
subject to
arise.
correction. They categorically states, Milord, in the petition affidavit that categorically said,
Where?
they had page 3, paragraph 6, that with
Yes.
reference to the statements made in paragraph 5 of the said application, and the contents are vehemently denied to the extent such are not matter of records, and repeat and reiterate the statements made in paragraph 6 and denies and disputes any other contention which is contrary. The answering respondent says, the Honorable High Court was pleased to dispose of the matter such and such with the direction. It is obvious that those applications to have obtained the minimum qualifying marks or above in terms of railway recruitment rules
Now
must be
slow,
appointed.
now slow down from here. From there, slow down.
Yes.
Against the vacancies available today, they are acknowledging. They are not, we don't know from where you have got an impression that they are out to deny you something.
But I
We have not
understand-
come to a denial yet.
But denial is that the entire foundation of my claim, they denied and disputed and it has no basis, they said. If
We
that
don't
is not
find, we
basis,
don't find any such,
Railway board,
statement.
my lord, that is my lord, my understanding, subject to what my lords will say.
No,
Page
see,
one-
let us confine to can. Because now all this development is part of the can. In the can, their stand is in paragraph 5 and 6. They say because of this pendency, hence question of the other benefits does not arise at the moment. In 6, they say they take note of the High Court's order that this is how it is to be done. So how do you say that they are depriving you of anything? That is what we are
But-
trying to understand.
But I understand because they said that as they said further that there was no direction by the High Court.
Where is this?
This is my lord, page 153.
No, that is prior to this scheme being made available to you. That is history now.
What is the kind of benefit they intend to offer, my lord?
That's why we are saying,
That
how
is
do you know as of today?
I assume, my lord, from their statements that they have said that my entire claim.
On basis of assumption whether the High
Assumption,
Court
Milord,
should
the
proceed, that is
presumption-
the point.
No, query is, my lord, that if the language is not clear, my lord, I have understood the language.
Therefore,
that-
there is something apprehension
No,
in your
because
mind,
no,
nothing
no, 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 no.
tangible.
My apprehension has some basis. If your lordships kindly
So
say,
we'll
the
see
respondent
if-
humbly said and the
if-
petitioner deliberately chosen to misinterpret the order and right granted by this honorable court.
Where are you
Most-
reading?
That is their affidavit, page 4, paragraph 9.
Yes.
And they clearly stated, the respondent humbly said that as per the extent rule in force, they are not entitled to any relief that was sought for before the Honorable High Court. 8 and 9.
Whatever it is, it has to be read with paragraph 5 and 6. These are just, see, these are
No, my lord,
routine matter. This is written in every
My lord,
affidavit.
kindly, my lord, have
This
the
is not
serenity
a
considered.
specific denial of any specific claim because no such occasion has arisen. You approach the court saying that, look, they are not counting my service notionally. I will be deprived of pension. The High Court's order of 99, therefore, is sought to be rendered nugatory. They have consciously taken a decision that, look, we have to do this. We are doing this. But we are keeping it in hold till the matter is pending before the High Court. They say all other consequential also will not look into right now because it is pending. So what is the deprivation we fail to see?
No, because otherwise, if your lordship say, my lord, that when he say that I am not entitled to any relief, my lord, that is the
Because now they are giving you, where is the question of saying anything?
Then, my lord, if he says only one sentence that the notional benefit will be given with regard to my pension, that is my claim. Otherwise, the persons who appointed subsequently by reason of a selection process, they will get more pension.
So therefore, we don't know whether that occasion will arise or not.
No,
Today,
that
we don't
absolutely-
know. Anticipatory order cannot be
No,
issued.
it is not a question of anticipatory. If your lordship says that this is of no consequence, that paragraph 8 and 9.
Obviously, because see what they have said in
But
paragraph
it,
7.
it does not.
Instruction
it
has been
also-
given to stay the order till finalization
It
of
does
the
not
matter of
say-
the High Court. Hence, question of other
It-
consequential
I'm extremely
benefits
grateful, my lord.
does not arise.
It
So
does not
once
say-
they do it, if the consequential benefits, there is any deprivation, there is an occasion, then you may raise a
No,
dispute.
because the Honorable Tribunal has said that the High Court, while granting relief, dated 29 January 2014, my lord, which I have shown to your lordship, page 29 to 31. Then, my lord, this relief was not granted in so many times, in so many words. Now, today, it is too late in the
No,
day.
but they are relying on the High Court's order only.
They are
They are not relying on the tribunal's order.
No, but
They have
question is-
taken note. You please see, they have
No,
quoted
your lordship is absolutely, my lord. But question is
paragraph
where-
6, they have said.
Yes, but where is such statement that I put this question to myself that I am entitled to notional pension? They have not said. On the contrary, they said that my entire claim is illusory. There is no
No,
claim.
that is a very normal and routine statement made in every
Then,
affidavit.
my lord, the state must come with a specific statement. Either I am entitled to notional benefit or not. It does not appear from the affidavit. The court is only concerned with the disputes
Let's
before the
see,
record.
let's see what they have to say. Let us see what they have to say.
Yes, my lord, I am for the High Court administration in another division bench. I took adjournment on all parties, my lord. This is an appointment of the judicial officers. I will represent, my lord. May I go there?
Yes.
I'm sorry, my lord. Yeah. If your lordship, if your lordship is not satisfied with his explanation,
Let us hear him.
Or-
He will be there. Yes. You come back.
This case has got two parts, my lord, according. First part is, my lord, they were interviewed, they are denied, they came before your lordship's court. This honorable court directed and they got appointment. What was the original prayer in the, my lord, that writ petition by which they have got appointment? My lord, kindly peruse the writ petition. I have filed this document by way of supplementary affidavit. This has been affirmed on, this is a supplementary affidavit filed on behalf of the respondents, and this has been affirmed on November 2024. Page supplementary affidavit, only the annex documents has been annexed. Has your lordship got?
12th November 24.
Yes. We have annexed, my lord, by this the original writ petition which they filed and in which they got the order. What was the prayer? Original way. At page 14, your lordship kindly peruse.
At page
14, 1-4. Serial number 8, relief sought for. My lord has got it, my lord. In view of the facts mentioned in para 4 above, the applicants pray for the following reliefs. To direct the respondents to cancel, withdraw the new employment news, that is Annexus C to the instant application, added with more qualification in cancel the earlier written test examination held on such and such date for recruitment to the post of TR, ticket collector and commercial clerk and inquiry cum reservation clerk. To direct the respondent and each of them to transmit the mallet or the records. Now, this was the original.
No, transmit the order documents, records, if any, which stand in the way of publication of the result of the written test held in so and so respectively for recruitment to the post of ticket collector and inquiry cum reservation. So they were seeking that the result should be declared.
Because the initial there was a publication, there was a fire hazards. That was the reason it was cancelled.
But
Yeah.
whatever it is now, the High Court, whatever the High Court says, you will have to go from there.
Yes. Now, my lord, what the High Court said. My lord, peruse the High Court order once.
So this is
That-
not relevant today. Today, what is relevant is what the High Court has said.
Yes. What the High Court has said, page 27. Writ petition, page 27. Grateful to your lordship. What is this order was challenged.
Against the vacancies which are available today, they have to be appointed.
That is
Yes.
available today. Thereafter, what happened, my lord?
So what is the date of this order?
Order of date of this order, my lord, was
2014.
yes, 29th January 2014. By the court order. Now, my lord, you will not find the case 33. Terms of the order passed by the 8 petitioners were appointed. This is the one of the appointment letter. I have to inform, this is Satyajit Malik, the first one, before your lordship. I have to inform you that you have been selected to undergo training at such and such, ECRC for a period of 37 working days, such and such, subject to your passing of the prescribed. All these things are there. You might kindly skip over. You are selected for the appointment against the working of the post. On completion of the training, you will have to serve Railway Recruitment Board for a period of 5 years required by the administration. This is serial number 5. This was the appointment letter. Now your lordships, they accepted without prejudice, nothing was there. Now after joining, on page 65, they have started thinking otherwise. Now they made a representation. No. The original way, the original representation, nothing was there. After this, my lord, page 65. New representation they made. The case made out a new case and filed a fresh way. This is, my lord, in the year 2016. After 2 years almost. This is purely an afterthought. Had they, my lord, pleaded these things before in the original way, and that was challenged before the High Court, and on the basis of that, considering the High Court would have said the situation would have been different. And this is not the case. They came, they got order, they got appointment, enjoyed the service benefit for 2 years, and 2016 they made a representation, made out a new case. And whether this representation was rejected by the way, and that is the subject matter before your lordships for consideration.
Any representation you had limited judgment and exceeded.
And your lordship kindly pay page 65 subject, requesting to give effect of the promotional benefit on the notional basis with effect from the date of judgment. That is my 2014. And
Page?
at page 1, your lordship kindly peruse page 65. The subject matter of the representation. Requesting to give effect of the promotional benefit on the notional basis with effect from the date of judgment. They are saying, and counting for consequent benefit, including the fixation of
From the date of judgment means which judgment?
2014.
14. Yes,
Obvious.
yes.
Now they are saying, my lord, 99 onwards, they are entitled to notional benefit.
In the OA. Where is that?
After that, after rejection of this
We
representation,
had just seen the prayer in the OA somewhere.
yes, yes. I have shown you your lordship by the first way. After
Page 6 and 10, prayer in OA. 6 and 10 of supplementary affidavit.
Page 98, the prayer, my lord.
page,
Supplementary affidavit.
no, supplementary affidavit, my lord, we have only annexed the first way, against which they have got the appointment. On the
Where is
basis
the prayer of the second OA?
yes, my lord, I get it. Second way, they have developed the case, my lord. Page 98, subject to correction, my lord.
Page?
98 of the writ petition.
Of the writ petition.
After disposal of the representation, after 2 years enjoying the benefit, they have thought otherwise. They have made a representation. They have the representation rejected. Against that, they filed this way. Prior A. An order be passed directing the respondent authorities concerned to immediately give effect of promotional benefit on notional basis with effect from the date of filing the original application. They are not. The Supreme Court has decided this point. A person when is entitled to notional benefit, I can show to your lordship, my lord, the judge.
Shows.
No, we part দেখি। This is reported in SCC online also, and I have not given. I am giving your lordship, my lord, to Well,
Citation date will
2024 SCC online. SCC online SC 1768. This is, my lord, I've got it from live law, but this has been reported in my lord also SCC online. My lord, kindly first come to paragraph 19 of the judgment, one portion. Bottom. My lord has got it, paragraph 19.
Just give us a minute.
Observation of the Supreme Court with regard to the promotional notional benefit.
Huh. Yes.
And the relevant paragraph, my lord,
Yes. Which paragraph?
paragraph 19, bottom portion, we are also of the view that no retrospective promotion or seniority can be granted from a date when an employee has not even born in the cadre, so as to adversely affect the direct recruits appointed validly in the meantime as decided by this court. This is the principle. My next page, paragraph 38. My next page, quotation, paragraph 38 paragraph. This court has consistently held that no retrospective promotion can be granted, nor can any seniority be given on retrospective basis from a date when an employee has not even born in the cadre, particularly when this would adversely affect the direct recruits who have been appointed validly in the meantime. This is the principle decided by the Honorable Supreme Court. But here your Lordship has seen the facts. 2014 they got an order on the date vacancy available, give them appointment. They were appointed. They accepted without prejudice. Nothing was there. They accepted in full. They enjoyed. After 2 years, my lord, they are saying that give us notional benefit from 1999. These, my humble submission, they are not entitled. They are bound by this.
They are bound by the judgment,
Of this principle, this judgment.
this judgment.
These principles laid down in this judgment. My lord, you are finally come to the conclusion portion last.
Yes.
Last page. Last but one page. Paragraph 30.
This is a very settled proposition. This need not be reiterated. Nobody can be given seniority from a date
Unless these portions,
unless he is born in the cadre. That is the law. Only from the day he is born in the cadre.
now my lord, he has come before your lordship's court and claiming that
No, but he is placing his claim on a different premise.
I'm coming to that point. But now, when the matter was pending before your lordship's court, by mistake or by right, another memorandum of issued with giving effect of the my lord, the pensionary benefit and other benefit according to his. He has challenged that, claiming benefit by filing a supplementary affidavit drawing the attention of your lordship's court that yes, now you have accepted, give us everything. That is a completely separate cause of action. This court, I submit before your lordship court, is decide whether the order passed by the tribunal valid or sustainable or not sustainable. Once this is held, well, that is a separate cause of action.
No, but we cannot ignore the subsequent development being the issuance of memorandum. To that extent, you have already agreed.
But agree
After that, of course, whatever they say,
to that my submission, my lord. There cannot be.
you are only withholding that benefit because this is pending. You have said in the affidavit.
That is my that to that my lord, Supreme Court has decided the principle. The Reed court, he cannot, what he has not pleaded, what was not case before the tribunal and case before your lordship's court when the matter Reed petition was moved, he cannot make out a third case and get benefit of that. If anything happened, my lord, that is a fresh cause of action, given or not given, that will be decided. But I have also judgment on that, my lord, and I am giving to you. Unfortunately, only one copy is with me, my lord. It is a 42 pages judgment, and I am handing over your lordship, my lord. This is also, my lord, reported in SCC online. If you look at it, they will give reply, my lord, to the SCC reference. AIR 2025 SC 195 Supreme Court.
AIR
2025
Yes.
SC 195.
Which paragraph?
And I am relying on paragraph 37 first. The paragraph may not tally with the AIR. Here the principle laid down, my lord. Based on the aforesaid authorities, we hold that while deciding a writ petition on the basis of affidavits, the writ court's inquiry ought to be restricted to the case pleaded by the parties and the evidence that they have placed on record as part of the writ petition or the counter reply affidavit, as the case may be. Findings of the court have to be based on the pleadings and the evidence produced before it by the party. It is impermissible for the writ court to conjecture and surmise and make out a third case not pleaded by the parties based on argument advanced in course of hearing.
They are not on argument. They have brought it on record now.
Brought it on record, my lord.
It's not that they are not, it is not on record and they are.
These are not pleaded in the writ petition, in the original petition and also in the writ petition.
Writ petition can always be supplemented. There is no bar to that. There the apex court is saying if it is not there, then don't do it. They have placed it on record. So that judgment.
On record by a supplementary event.
Correct.
My submission, not subject to your lordship, my lord, what?
Yes.
And another paragraph, my lord, I am belonging. Huh?
195.
AIR 190, SCC নয়।
AIR.
ও SCC টা দিয়ে দেন।
না, AIR টা মিলছে না। মিলছে না। 195 page.
AIR 25 SC you said.
Well, I am also supplying the SCC online. I am also supplying.
You give us 2 copies also.
My page, here, my lord, paragraph 49. Finally, we consider it essential to say a few words about the approach adopted by the division bench in relation to postdoctoral experience referred to in clause 7 of table 3A and 3B. It is plain and clear that respondent number 1 did not question the same. In fact, noun anomaly had not been referred to by respondent number 1 in her writ petition. In the absence of any definition of postdoctoral experience, as well as a complete lack of pleadings in regard to such experience earning marks, but assuming that there was good reasons for the division bench to notice a gray area, either the UGC or appellant ought to have been asked to clarify. Without seeking any clarification, it is not open to the division bench to surmise and conjecture and to be guided by to a particular direction based on a perceived anomaly while giving its decision. We are inclined to believe that the division bench, in the absence of the clarifications that are closely associated with this decision, ought have adopted a hands-off approach in this regard. Now I am handing over to your lordship, my lord.
There was no pleading, sir. Here they have pleaded, you have responded, how that judgment will apply.
That's my lord.
It's not a case that they have not pleaded, that is a presumption in the mind or anything.
Subsequent event, they have pleaded.
This is not on subsequent event. This is on when there is nothing pleaded, can they do it? They have pleaded, you have responded. They have replied. Where's the question of no pleading?
By which words we have responded, your lordship kindly consider this. How
It is a different thing. We are on this judgment. That judgment is not covering the facts of the present case. There is no absence of pleading. There was no pleading whatsoever. Therefore, the court says, how can you surmise on such a thing?
my submission means the not pleadings in the writ petition. Not pleadings in the writ petition. They original way or in the writ petition. They are bringing this fact in course of hearing by filing a supplementary. By this way, they are bringing within the four corner of the pleadings. This is, but now your lordship to my lord consider and decide the issue.
Give us 2 copies of the judgment.
Should I hand over to your lordship?
Give us 2 copies.
Yes, I shall do. And by which way we have responded?
What? Is 30. Is 30. For that, this will also apply because when it says from today,
My lord is deciding this petition as an appellate court. My lord, they have pleaded their original pleadings before the in original application before the tribunal. That my submission that is not pleaded, my lord. They cannot improve their case before
see,
the-
that is a different point. That is an issue which was not before the tribunal. If it has arisen, they are required to go to the tribunal again. That is something else. You are saying that no pleading. There is no case of no pleading. They have pleaded everything.
My lord, what is the subject matter before your lordship? My lord, subject matter before your lordship, my lord, the judgment delivered by the tribunal. Whether this can stand or not. My lord, this is a correct judgment or not.
So therefore, then what you are saying is, whatever the tribunal has decided, only that is the subject matter of the present proceedings. Anything subsequent thereto, if they want to raise it, they have to do it in accordance with law. It cannot be done here. If this is what you are saying, then that is a different. Yes.
Yes, sir. If they have completed, my lord.
Hmm. Yes.
And one other, when your lordship kindly paid is one affidavit, they have filed before your lordship pursuant to the direction passed by your lordship. This was affirmed on 18th February 2025. Because my lord directed that you please clarify your stand, what you want. To that, they have filed an affidavit. This is dated, my lord, 18th February 2025. Affirmed.
Oh, you couldn't put me, I can't. It is disorganized by nothing.
You can have a number, oh, document number. It is very thin, my lord, 7 pages.
Page 5.
My lord has got it, my lord. I am relying page 5, paragraph, my lord, 11.
There in the OA also.
Now,
This was their prayer in the OA also, the second OA.
they are not entering.
They have only elaborated on that if it is granted, then we will get all these benefits. It's not that they are asking.
Their prayer is, my lord, the representation from the date of the judgment, your lordship has seen. Their representation, subject matter was the date of the judgment.
Yes.
This is my respect.
But my prayer before the learned tribunal is clear, my lord, which is in page number 98. But my relief was that order be passed directing the respondent authorities concerned to immediately give effect promotional benefit on notional basis with effect from the date of the filing of the original application. It was there, my lord. And my lord,
So therefore, in this affidavit also you are saying 99.
yes.
Therefore, we said ultimately the prayer in the OA is to grant it from 99 because you filed the OA in 99.
Right.
And you have only elaborated that if it is granted, you will get all these benefits.
Because my lord, the delay is not purely attributable to the applicants. but
That
the
has already been
petition-
argued. So they have argued 2 points based on this judgment. They say that prior to the date on which you have been appointed, you cannot get anything. Second is that they are saying that new case is now being made out,
Yes.
which was not there in the trial.
But well, this is a subsequent development which we have annexed the supplementary affidavit. There, the application we have filed, the memorandum, the office memorandum which you have relied upon, that is a subsequent development.
So that they are saying they have kept it on hold because this is pending only. If it is over, then whatever is due under
have-
that memorandum, you will get it.
From the submissions made by my learned senior friend, it is clear that they will deny our prayer.
Hmm?
They will deny our prayer because
They will deny?
our prayer.
No, not prayer. They are not going to deny the memorandum benefits.
Memorandum benefits, my lord, according to the submissions, my lord.
Yes.
But the relief, my lord, what we have fought for,
That
would be,
they
my lord,
are disputing.
Yes.
That they are disputing. But the memorandum which has been issued, that they are not backtracking on.
yes.
They are saying it has only been kept on hold because this is pending. The moment this is over, you will get the benefits.
And well, in addition to that, my lord, in 2014, when my
On that we are clear that benefit is only withheld because of the writ petition. The moment it is over.
that is the thing, my
No,
lord.
where is the question of deciding? Where have you said that we will decide after the writ is disposed of? Please show us from your stand. Now you are making out a new stand. You see what you have said in paragraph 5 and 6. Instruction has been given to stay till finalization of the matter. That is all. You are not saying that some new decision will be taken after that.
Advance schedules, Varad. Paragraph 5. What your lordship?
That is what we are reading. Exactly. Instruction has been given to stay the order till finalization of the matter by the High Court. Hence, the question of consequential benefit that you say that will be decided later. What they are claiming that from 99 you gave. But you have not said that this memorandum will not be extended.
And may I place this from the is with reference to statement paragraph 3 and 4 of the application and the contents are vehemently denied to the extent such are not matters of record, and repeat, the answering respondent states that matter came to notice through can such and such, where the read petitioners were allowed to switch over from NPS to OPS by SDAH division of the railway. This is a case of switchover memorandum. After thoroughly examining the issue with existing rule in force, it was found that this could be done either by ignoring the stipulation of RBI or by lacking information regarding the pendency of the writ petition number such and such. Instruction has been given
To stay till finalization of that is all.
finalization of the
You are
matter
not saying that fresh decision will be taken.
say.
Yes.
Hence, question of other consequential.
No, other benefits we are not on. We are only on the memorandum benefits. Other benefits we will decide whether they will get or not get. Memorandum benefit, you have said it has been stayed only for finalization of the High Court.
Entire.
Yes.
The railway board's notification such and such stay of the order of switching and the office memorandum annexed. Now your lordship kindly peruse paragraph 7. That with reference to the statements made in paragraph 6 of the said application and contents are vehemently denied to the extent such are not matters of record, and repeat and reiterate the statements made in paragraph 6 of this affidavit and deny and dispute any other contents. The answering respondent states that petitioners have suppressed the fact before the administration that the matter is sub judice before the Honorable High Court, Calcutta. In addition to this, they have approached the railway administration seeking the same relief. As per directive of the Honorable High Court, Calcutta, the applicants were appointed against the vacancies existing in 2014. Hence, this recruitment of railway is an exceptional one, which does not come under the purview of this RBE. They are this time. Now, paragraph 8.
What is RBE 41?
That is that they have switch over. The switch overs. That is the memorandum. Memorandum.
No, we want you to be clear on this. This memorandum which you have allowed giving their names at serial number so and so, that this is being extended to them. Has it been withdrawn ever?
My your lordship, now peruse paragraph 8.
No, forget about it. Where is your decision? Affidavit is a different thing. You have issued a memorandum
Further,
giving the benefits to them. That benefit, whether it has been withdrawn or it is pending decision of the writ petition. From here it.
My lord is asking me a question to the authority whether, apart from the affidavit, exchange of affidavit, whether the authority has.
No, there is no question of whether. If it was, you would have said so in the affidavit. There is no such.
Paragraph 8, your lordship can.
Yes. No, that is a different thing. That is a
Yes.
general averment. Those are general averments. That means nothing.
We have stated the right to withdraw is there.
We are asking you about the switch over that you gave by giving their names. You have taken a conscious decision.
Why this decision was taken, that has been stated in the opposition.
Where is that order?
That is at page 12 of the same opposition. The lordship will get.
Paragraph 4, my lord, your lordship can kindly see, my lord. Paragraph 4 of that office memorandum.
Please.
This benefit 1999 থেকে আমাকে benefit করে। This scheme does not say about that. It only allows you to switch from 78 scheme or the 2003 scheme, which is a one-time option given to switch. It is not covered.
Covered under the. It has got nothing to do with this.
They will be given this benefit if they have applied on the cutoff date. The question is not there.
It is in opposition to the main writ petition.
So wait there.
My your lordship, once peruse, my lord, the affidavit in opposition of the main writ petition. Of my affidavit in opposition to the main writ petition, it has been affirmed on June 2024.
Page 12.
It starts with page 12, annexure R3. It is notified on or before. So you know the benefit.
এটা cutoff date আছে application করেছে কি করে না ওটাও আমরা জানি না।
Exactly. Well, this
We
type
have
of,
to-
well,
we have
this
to-
type of writ petition should be heard by paper book. So many, yes, well, I follow your lordship difficulty. This should be
Or
such-
several applications,
so many.
but may we file one paper book, my lord, in order to assist. But several,
by-
my lord, oppositions and supplementary affidavit.
Yes, well, this is, yes, well. And any mistake done, my lord, then we'll come before the court, my lord, that this is mistake. Now, this should be heard
We
by.
filed only one applications and two affidavits. my lord. No, my lord, but I apologize, my lord.
Yes,
No, my lord, but I apologize, my lord. I have difficulty, my lord, I understood. I have understood.
আমরা একটা নোট বানিয়ে দিয়ে দেবো। পেজে কি কি রিলাই করে যদি
my would you
Well,
like
well,
to fix another date? We'll come with the list of, my lord, the pages, relevant pages. No, otherwise it will be very difficult for you. Impossible, impossible.
But we'll
They will.
We'll prepare, well, we'll
myself
prepare.
is being confused, my lord.
we'll prepare a
I-
my lord,
At the threshold, I requested my learned friend, well, this cannot be. I mean, I asked his senior, my lord, this cannot be done in this way, Judge Sahib. My judges will face difficulty, you prepare a paper book and come. I requested him. Yeah,
my lord. And may we file one short notes, my lord, so that indicating the page numbers, so that it will assist. But indicating the affidavit
weekend এ বানিয়ে আছে পুরো বান্ডেল
আচ্ছা
ভালো সময় এক সপ্তাহ পর
ডিটেনশন করা এটা ওভারনাইট বানিয়ে দেয় ওরা পেপার we will be able to make the paper book and come back by Wednesday not a problem হয়ে যাবে it takes nothing না এই ডকুমেন্ট আমরা রিলাই করি
my lord.
একবার প্লেস করে দেবো
কত তারিখ মঙ্গলবার
কবে কবে রাখতে হবে
12 তারিখ
হ্যাঁ মঙ্গলবার
পাচ্ছেন না তো দর্শক মে আই রেফার ওয়ান অ্যানাদার থিং ঠিক আছে পরে
That would be difficult.
well next day we
But next,
next day we'll show it. We feel how your lot
pass that all OA has to be filed by way of a paper book with index, then it will suffice. We will all have to do it.
এখন তো
Time to time, other benches have been doing that. That's why we file it.
initially it was only application.
Appeal, there's a provision after admission of the appeal. Court
Yes,
passes
yes.
an order that informal paper book may be filed because formal paper book requires typing of all documents. And informal, we can annex the document.
My lord, initially it was application, opposition and reply. Subsequently, some affidavits, applications filed. That is why, my lord, it was cumbersome.
বলছি যে এত শর্ট টাইম নিয়ে যাতে করতে পারে তখন আবার
DDs came here as a result of which there was additional documents. Otherwise, as it is coming from a tribunal, the entire document was already there.
One, please have a look at this rule 20. Both of you. It is our high court rules. We should all know it.
other matter your lordship direct so that your lordship do not
Where is a question of direction? The rule mandates filing in a paper book form. That had to be filed as a paper book.
That is a rule.
And you want us to give an order? It clearly says all petitions, this is 226 rules, have to be filed in a paper book form with index along with a short list of dates and a statement of the points of law involved. Where is this? You are making us shuffle through to hundreds of pages. Nothing is in order. There is no coordination between our paging and your paging.
That will be.
The sum and substance of
Item number 12,
This condition is not good, Lordship.
Huh?
Advocate Shobhu Chatterjee, Lordship, his health condition is not good. He's not present at court today, Lordship.
He has not come.
Kindly not today, Lordship.
Not today. Monday, we have anything at 2 p.m. Adjournment is paid for on
প্যারাশুদ্ধ পূর্ণেশ্বরী
item number 13,
13, my lord, I am for the petition, my lord. May I hand over the compilation of the argument? না না এই আমার এটা দিয়েছি এটা জানো কম্পাইলেশন চারটে ছটা ছিল দুটো কমিয়ে চারটে খুলে দিলাম।
এই জন্য ভুল এসছে চক করে
কালকে আজকে
You have already referred to this. Could you make it clearly or should I call the order? Days. Today it is under the heading for orders. This is yeah. Thank you. অর্জুন রায় মুখার্জি আর শুভেন্দু সেনগুপ্ত
ওই তো একসঙ্গে
13 to
16
বলে দিই 13 to 16 identical
Item number 19 and 20.
Lord, in respect of item number 20, I beg to appear for the petitioner, my lord. My lord, this is those matters where the age bar is in question, my lord.
On the last day also, I have said now these matters,
Yes.
Mr. Rai had informed that perhaps some matters have been sent to the Supreme Court. So if that is the situation, then we'll not proceed. Till now, we were following the earlier order. So we have fixed those matters when the other
My lord
case,
has already passed order.
Now, my lord,
My lord has covered those.
last day,
the last petition also is subject to document SLP is in queue. We are in the process of submitting SLP.
no, Mr. Rai told me that 4 or 5 matters have been sent.
Including those also.
So we wanted to know whether he has sent those also on which we were relying. If those have also gone, then we'll have to wait.
Same issues are involved.
Yeah.
Last occasions I appeared on 2-3 matters, similar issues, age bar and whether.
In 2 cases, we have passed the order.
Yes, sir. In 2 cases, my lord.
Cases we have passed the order. After that, Mr. Rai, the other day we were making a modification. He informed us that those matters.
That SLP.
So the other matters which were taken up 2 days back, we have adjourned them to which date?
Or same matter.
When have we adjourned those matters? That is so that it.
Take up this matter after 3 weeks or 4 weeks, adjourn this matter for the time. 19 and 20.
We are.
Why we can, there was no candidate. Candidature was sent for medical examination. Are you satisfied order of Congress? On our own motion, they has not allowed a single marker for the.
No, therefore pick and choose. If you are complying for one, why you should not for the other? Why you have to wait for an order for the other? Either it is right or wrong. If it is wrong, you have to take the order to the higher forum and get it tested. If you are complying, then in the next case, how you can take a different step? Anyway, so when it will come, we'll see. Now it is to be decided.
My lord, একটা minute.
The opposition, I've already served the
Give it. It is an opposition.
exception, my lord.
Huh?
Opposition, they have filed. I have referred.
Exception is taken on record.
My lord, sir.
24 years.
All
Matters now, those land loser matters, unless the order comes, will not take up.
That is my matter that pertains to PET.
Any matter. So we'll pass the same order. Give the serial numbers in which you are appearing. And other side is present, I hope. Huh?
54.
Giving the case number. Just now tell us you were appearing in which matters?
Item number 20 and 54.
20 and 54.
20, my lord, has already passed an order.
Yes. 20 is with 19.
Yes.
So 19, 20 both. And then 24.
50, my lord.
54.
Four.
WPCT 263. And which other matter?
My lord, 24 and 25.
24 and 25. So altogether 5 cases. Got it? 4 weeks.
Ships.
আমি লিখে দিচ্ছি না পড়টা।
Item number 21.
Lordship, in this matter, Mr. P.C. Das is appearing on behalf of the respondent. Some medical emergency, Lordship, he is out of station, Lordship, playing for 1 week time.
1 week. As paid by
উনি ষাট দিয়ে দিলাম
Copy fixed করুন।
অনেক করেছে।
ঠিক আছে দিয়ে দিস 22 এখানে রাখছি কেন
সেম সেম
appears on behalf of the
But I have received.
item number 23
But I appear for the petitioner.
opposition
But I have received the opposition. My lord.
today.
Day before yesterday.
Then
I reply, my lord, I will.
how much time do you want?
As your lordship.
Tomorrow?
Almost the similar points have been taken by the state and.
So therefore we are asking you, is reply is necessary or this, we can proceed. We will confine to the document, we will confine to the records before the tribunal. If there is something new,
No, my lord, my lord, the fact remains, my lord, the tribunal decided that the matter would be taken up by the division bench. And there is no division bench and I have come up before your lordship. One point of maintainability have been taken. I am been led by Mr. Vikas Ranjan Bhattacharya. Judgment of the point of maintainability have been taken, my lord. I have one judgment which specifically says that when the tribunal is not in session, the High Court can hear it out. And your lordship has already heard it out and made it for affidavits, but maintainability point was kept open.
so therefore it is open to argue. It's not that issue is concluded yet.
Hello?
Maintainability has not concluded yet.
Not yet concluded, yes. But I have. They are also in the affidavit, my lord. I have found they are not taking the point of maintainability. Though, my lord, oral submissions in this regard have been made.
Anyway, that is something which can be objected to orally also.
But
Once we have given the liberty, they can argue.
Paragraph number কত? Well, specifically, there is a judgment. In paragraph 392 of. Well, I have brought the judgment on regard maintainability. আপনারা maintainability নিচ্ছেন? হ্যাঁ? The judgment of Supreme Court, my lord. 5 judges bench. বলে দিচ্ছি citation. এক মিনিট 2020 volume 6 SCC page 1. My lord, I'll just refer one paragraph only. This judgment is a big one, my lord. It is maintainable, my lord. Paragraph 392. No, administrative tribunals. 2006 SCC
2020.
page 1. Paragraph 392, my lord. Because ওকে ডাকো না।
Of the ratio of the judgment could be made applicable here.
My lord, may I just read it out, my lord, subject to your lordship's correction. My lord, paragraph 392. The litigants cannot wait. Paragraph 392. One paragraph I'll rely on. It's after L. Chandra Kumar. The litigants cannot wait for judicial impact assessment and action by the government which may or may not take place. Experience has shown that the judgments right from L. Chandra Kumar to Madras Bar Association 2010 have not been complied with by the union in letter and spirit. Citizens of this country cannot be denied justice, which is the first promise made in the preamble. Therefore, I am of the view that in whichever state, union territory, the bench of a particular tribunal, my lord, I read it, is not established or functioning, the litigants of that state will have a right to invoke the extraordinary writ jurisdiction of the jurisdictional high court under Article 226 of the Constitution for redressal of their grievances. So, my lord, as on date, there is no division bench. As on the day of affirmation of the writ petition, before this High Court, there was no division bench. And the single bench, my lord, of the tribunal has sent the matter to the division bench, considering the fact the previous judgment through which the entire panel was published, my lord, was from a division bench order of the tribunal. That is why, my lord, I'm been led by Mr. Bikashwani. So, my lord, I have before your lordship. So, your lordships are having jurisdiction even after L. Chandra Kumar if it is not functioning as of now. And this is admitted position, my lord, so far as the maintainability is concerned.
File the reply.
States, my lord, I will file a reply.
How much time?
1 week.
As plead matters that.
কবে রাখলো? Action.
Mr. Mukherjee, you were telling us that
To appear on 15th, but 15th is a holiday. So 1 week hence it's on 15th of August.
Next Friday, I think it's a holiday.
obvious.
But we are facing another difficulty so far as OBC is concerned. Now OBC is concerned because one judgment has been delivered by our division bench, but a SLP has been filed. thrice it was taken up for hearing.
No stay by the SLP, my lord.
No.
I am also appearing other side. My senior is there for the state. No stay.
No, what matter has been fixed for hearing. Another, according to the subsequently government has amended such an amendment that was challenged, that was stayed by the Supreme Court. Again, we have challenged that order before the Supreme Court granted stay. Now,
Subsequent notifications have been stayed by the Supreme Court, but the previous judgment of the of this honorable court has not been stayed by the Honorable Supreme Court of India. The new notifications which have been made that have been stayed by this division bench of this court. In the apex court, my lord, state that interim order, my lord, Monday it will be taken up. Earlier matter is still pending. There is no stay by the Supreme Court as of now.
but matter is fixed for hearing. One day matter was appearing, item number 11 could not be taken up for hearing. Another matter, item number 21 could not be taken up for hearing.
My lord, the state can proceed with the recruitment with the notifications as it was before 2010 with 7% OBC. State is, my lord, trying to drag to 17% OBC. Recruitment and admissions, my lord, may not be stopped. That is one aspect of that matter. State is saying that we cannot do helpless, but previous 2010, my lord, recruitments were there.
It is ultimately, I do not know what would be the happening before the Supreme Court. If it is ultimately the state's appeal is accepted by the Supreme Court, then the entire selection process will
The
be
judgment was passed, it was a prospective effect. So that will also affect a prospective effect. Let's see. Great.
Item number 26 to 30.
দিতে হবে না মামলা item 26 to 30. These are a batch of matters which have come up for my lord's kind consideration. Truly speaking, I am facing extreme difficulties in my house because my auntie, who is a 80 years cancer patient, she has been admitted to ICCU. And every day from court, I am going to ICCU. And from there at night 12, I am going to my house. I could not read anything. Therefore, I was only humbly praying that if your lordship grants me at least a week's time, but my learned friend has some difficulties. He is also appearing in one matter. He is saying that if your lordship
29 and 30.
any Milord, because any date Milord which suits my lords. I am facing extreme difficulties which
Any date after how much time? What is the difficulty period?
difficulty, Milord, I think it will be over by another 7 days. Whatever way I say.
After 18th, any day,
After 18th,
I have no problem.
25th?
ঠিক আছে 25 ওটা একবারে যখন হবে তখনই করে দেব।
A supplementary. So if you file a supplementary, then they will file a opposition then.
that opposition that has been filed by the respondent before the tribunal has been got annexed, although there was a mark.
Only that you are placing. In which case?
WPCT once
item numberটা বলে দাও।
item number 30 মনে হয় দেখো।
This is 26 to 30. This supplementary you are filing in which matter?
29, 30 I am appearing for that petition.
26 to 30 is together. Supplementary you are filing in which case?
176. Item number 30.
So in 30, just add supplementary is being. All right, as jointly prayed, list on 25th.
7. Item 27. Yes.
Supplementary is taken on record. And all the orders 28 में add कर दो opposition. Yes, give appearance.
Look, kindly excuse me, I am just.
No.
Yes, I am in such a position that I will. Without the order.
144. না একই সিঙ্গেলে আছে, আগেরটা সিঙ্গেলে আছে, আরেকটা আছে দেখুন। Item number 31.
Lordship, 31, I am praying not this week, Lordship. Lordship, the problem is advocate record, Mr. Ratul Vishwas leg is fracture, Lordship. They could not come to Mr. Shamnal engage in another court, Lordship. That's reason, Lordship, I am praying.
With this order, they have started to stop. There is a question we had raised. Filing of successive writ petition. You are for the petitioner. Whether a successive writ petition can be filed for the same relief. That question we have raised in the order of 16/5/25. We have a doubt appearing in 31. You are appearing in WPCT 144.
My lord, sorry, I'm for the respondent in my lord.
I am for the
My lord, I
petitioner.
got mixed up with two cases, my lord.
Yes, once we have put that query again and again, adjournment is being. No, it cannot. What is this? we have put a specific query after that. This is the third agenda. Either you respond to it or you don't. Ask him to be here, not today. We are not going to pass any order.
Item number 32. 147. File কোথায় রেখেছো? সার্ভার করেন সার্ভার করে আপনি জুলাই একটা অর্ডার আছে এটা সার্ভার করেন কি এটা বাবু সার্ভার করে
Just not today. Don't pass.
33.
Lordship, I am appearing on behalf of the respondents. I'm praying for an extension of time to file my affidavit. The reason being that my learned junior had fallen ill, and after that, the officer who has to affirm is suffering from viral fever. But we are ready. We have sent the affidavit to the department. Only it needs to be affirmed.
Next week.
Kindly gives us another 1 more week, Your Lordship.
Item 34.
AFT,
AFT.
yes. So RMB will prevail or record officer will prevail. That is the issue.
RMB will prevail, my lord, in this matter. Earlier, a respondent filed OA in the AFT, and the same was disposed of with the direction to pass the speaking order. And the speaking order passed, my lord. I would like to invite your lordship attention in speaking order, page 50.
50.
50.
Who has considered his ID?
Uh,
It's not legible. Why do you file such documents? How can anyone read this? How can anyone read this? Why should you file it like this? We are sure that even you cannot read it. Can you read what it says? Please read the third and fourth line at the top.
Second appeal, a rising white honorable AFT RB Kolkata court order dated 22nd June 2015, filed by the ex-Nayak and Nitai Sikda, white OA number 111 of 2013, and his execution petition number 02 of 2016 against the rejection of disability pension has been examined by the second appellate committee on pension.
Yes.
My lord, I shall file the true copy. My lord.
You have to wait for us to say this.
Leave may be granted to file, my lord, true copy. Written to, I will file, my lord, by supplementary affidavit.
Which documents? Then you will
Every
get
document
some
which is-
other
every
document you will
document which is-
rely, then that will also be
No,
illegible.
my lord, every document which is not legible, I undertake to file, my lord, true copy. Type true copy. I tender my apology, my lord.
File a proper paper book.
Paper book, very well, my lord.
He has he was the of the tribunal.
Yes, my lord.
So application, opposition, everything is there. Then file a paper book.
Very well.
Stop. it is not informal, then it is
Item number 35.
Lordship,
That will be done by the department. Then why the rate code rules 226 rules says that it has to be filed as a paper. So where is the question of formal informal? There's no order required. See, all petitions must be filed in form. Documents supplied. This is for articles 226. Annexure are to be marked in this way, and all the papers have to be on the same side. This is the requirement of the rule. And this has to be checked. There is an authority who has to check it also. Before any matter is listed for the office, before whom the petitions shall certify that all first prescribed under the rules, including class, have been all formalities. So this is also a formality. For every case, you have to attend it 2 or 3 times to make it just legible. Then you hear and then your opposition. My God, 5, 6, 2, 6, 8. Yes.
in this matter, a similar matter was pending before the Honorable Supreme Court, where a stay was granted and time to time we had
Oh,
informed.
yes, you have informed us
Yes.
earlier also.
Again, that stay has been extended till the 12th of September.
Is continuing.
No, I'll just hand over the.
All right, well, the last order has to be repeated then.
Yes.
The last order is
It's till the 12th of September now.
still a diary number.
No, Lordship, it's recorded item number. No, it's got the SLP number.
4308.
It's yes,
4308.
4308. SLP number
4308 or 4309 or 2025.
4308 and 4309.
4308-4309.
With SLPC, there was another one. There are 2 more.
There are 2 more.
Yes, with SLPC number 17993 and 17994.
Where is that?
Lordship, just below the cost title, Lordship.
So the lead case we can mention, that
Lead
is
case,
the
that
other.
is sufficient. The lead cases.
We are informed by the learned
36.
Respondent. my lord.
On the previous occasion, trustee inquire about the whether inquiry officer cross-examine or not. And I am supplying this book.
What does the rule say? Presenting officer is not required.
Presenting officer here, no here, but he cannot cross-examine.
No.
Presenting officer, inquiry officer cannot cross-examine. It may be required, not required, but what-
Can, my lord, can, my lord,
this is the.
there is a, my lord,
I am,
notification,
I am
the railway authorities, my lord, and the master circular 67, my lord, can you see?
What are you showing?
My lord, this is, my lord, 9th May 2021, my lord. Railway board, my lord, sending all the general manager. Procedure to be followed, conducting the departmental inquiries and the role of the inquiry officer.
Yes.
Yes. Here, my lord,
Give. What does it say that presenting officer is not required?
no, my lord, inquiry officer, my lord, can, my lord, cross-examine the witness.
So,
Yes. And my lord, another master circular 67.
where does it say? Show us.
Page 3, my lord, 3.1.
Yes.
The crucial fact of the personality official conducted departmental inquiry is impartial approach. Is performing the quasi-judicial function. His conduct must be proved board so that should not merely impartial but can see to ensure the inquiry command to the confidence is deserved as per the assume where no presenting officer, it is not feasible to appoint uh, inquiry officer has to examine and cross-examine the witnesses, including the defense witnesses, to find out the truth of the charges. Page 3, 3.1 paragraph. And my lord, another my lord, master circular 67. The my lord. Or next, my lord. Next, my lord, master circular, my lord, next page, my lord, clause G, my lord. Where, my lord, G, my lord, next page, my lord, clause G, where no presenting officer has been appointed, there should be no objection to the inquiry officer examine and cross-examine the witnesses as he appointed find out the truth of the charges, and such examination and cross-examination is aimed at the end only. However, the inquiry officer should refrain from searching cross-examination as this might role is impartial authority. That is, my lord, board letters dated such and such 20th October 2071. 19.
Paragraph 3 clearly says, however, he should obviously avoid searching cross-examination. You are reading 3.1 without reading 3.
Avoid, but my lord, he can, my lord. My lord, two notification, my lord. One, my lord, 20th October 2071, and another is, my lord, 9th May 2021.
This cannot override your rules. Where is your rule? We asked you to show the rule. Why are you showing this circular?
The rules which, my lord. The railway servant discipline and, my lord, appeal rules.
That has
1950.
to prevail. This cannot supplant the rule. This can only supplement a rule. Give us. There is another bench. His lordship has to sit in another bench. So we rise.